The next case is People versus Thompson. This is a mini oral argument on the application. 15 minutes per side and 5 minutes for Amicus, the Innocence Project. You have 2 minutes of a free fire zone and you may reserve time. But we ask that you keep track of that on your own.
Good morning, Your Honors. Jacqueline McCann from the State Appellate Defender Office on behalf of Kevin Thompson. Trial counsel's performance was objectively unreasonable with respect to the polygraph and the post-polygraph questioning in several ways. He sent an inexperienced teenager alone to deal with a skilled professional interrogator. He did so without making sure that there was an ironclad written memorialized Leonard agreement, which he thought he had, but which had not been memorialized. And he took no other steps to mitigate the risk to his client, such as one would take if you were preparing someone to testify. There was no dry run, there was no private polygraph beforehand, no advice. You're sending an inexperienced teen into this interrogation. That is a bad equation, whether you believe your client is innocent or guilty, because these interrogators are skilled at getting admissions. As the prosecutor testified, that's the only reason she does these things, is to try to get admissions. And we know from the research that the Innocence Project has provided in their amicus brief that these techniques work on teens and other vulnerable individuals, particularly, whether they are innocent or guilty, and that's why we have exonerations that involve false confessions. So none of those mitigating steps were taken. And then once the disaster happened, that came to be, counsel did not properly litigate the motion to suppress when he failed to testify regarding the agreement, when Judge Fullerton told him, you need to testify in order to show that there's some sort of agreement that wasn't followed or that you had a misunderstanding about what the agreement was. And he didn't do that. And then at the Ginther hearing, when he did testify, and he testified he thought he had an agreement to two things. One, that he would be available in the building, and two, that there would be no post-polygraph questioning. And the second judge at the Ginther hearing thought that she didn't need to make factual findings as to whether there was an agreement that was binding or a misunderstanding, because she thought it was irrelevant, that it was only a totality question under Edwards. The problem is you can't do that totality analysis fairly if you don't have the full picture, which would include whether or not there was a Leonard agreement in reality or there was a misunderstanding about a Leonard agreement. So Kevin was prejudiced by A, not being able to establish the Leonard agreement, or B, not being able to establish there was a misunderstanding about having a Leonard agreement, which would still entitle him to relief under Streeter from our Court of Appeals.
Counsel, I'd love to jump in here. Perfect segue, because I wanted to ask about Edwards. Do we need to find ineffective assistance of counsel to get to Edwards here? I mean, I'm just wondering, there's no dispute. There was an agreement that the defense attorney would be at the polygraph at 7, correct? 7 p.m. I don't think there's any dispute about that.
I don't know that it's disputed. I think the trial prosecutor testified she really had no memory of any of this stuff.
Okay. So is there a fact question on whether there was just an agreement that the attorney would be present during the polygraph being administered?
The second judge in time at the Ginther hearing, I think may have said that Mr. Scott had some sort of understanding that he was supposed to be present, but I don't know that either judge actually made a finding of fact about anything having to do with the agreement. Okay,
so your position is then that counsel had to testify at the hearing to sort of flush that out?
Yes, Judge Fullerton said, you two need to be witnesses if this is what you're claiming, and then in her ruling said, there's nothing on the record before me about any agreement.
Okay, thank you.
But as to whether this, needs to go through IAC or whether it's pure Edwards, so we raised it as IAC because the totality of the circumstances was not fully considered because it wasn't put on the record. But, of course, we did that, and trial counsel, to be fair, litigated that motion before this court decided Stewart, which would have, given more guidance on the Edwards analysis for a teenager, particularly. So, this court could remand in light of Stewart for a pure Edwards analysis. But I do believe it's ineffective assistance of counsel not to present the totality of the circumstances when it's a totality test.
So let's just assume that the record shows that, I realize we're making assumptions here, but that there was an agreement the lawyer would be present when the polygraph was happening. Do you believe we can get to Edwards under that fact pattern, that, he had a deal, that I need to be present, even though I can't be in the room? And obviously the prosecutor is arguing that the client could sort of waive the privilege at the interview. So we know Edwards says once it's asserted at that point, you can't just waive it normally. So what's the difference here?
Okay, one factual distinction, he believed there were two aspects of the Leonard agreement. One, his presence in the building, and two, no post-polygraph questioning. Both are important. So after Montejo, Edwards, I believe it says in it, Edwards, Miranda, and Minnick are alive and well. So if you look at the analysis in Leonard and in Streeter, they use a couple things. They sort of use contract theory. The two parties had an agreement, it was violated, that makes your waiver invalid. But they also coach it in terms of it's an invalid waiver because if your attorney doesn't understand what is happening and why it's happening, then your attorney can't convey that adequately to the clients to allow them to make a valid waiver. And surely, even if there was some question, I believe, that Ms. Hansen may have said, or Detective Dwyer may have said, I never allow them in the room, and whether or not there was the post-polygraph prohibition. But even Mr. Scott testified, had I been there, even if he didn't ask for me, I would have stopped this because he had one prior experience with an FBI agent where he was able to visually see and hear what was happening in the polygraph room. And he described almost coming to blows with the agent because that agent tried to do a post-polygraph examination, which he wasn't supposed to. So at least Mr. Scott had knowledge of how much time this should take. And once it took 2.5 hours without him, once it went past a half hour, he's gonna know they're up to some shenanigans and he's gonna go in there and stop it.
So we know that police aren't precluded from lying in the context of interviewing a witness. Is there authority, or tell me what the best authority is for the idea that while that may be okay, they can't lie in order to obtain the waiver?
Yes, Your Honor. So you're correct, of course, that courts say that police officers can lie about the allegations and they can lie about evidence that is present in the case. But as I think Judge Krause spelled out in her dissent, I believe she cited to Moran versus Burbine and some other Michigan case law, that they're not allowed to lie to you about your constitutional rights or what your attorney said. So there's a line in some of the cases about, if counsel isn't in there with you once you've already invoked and they're allowed to come back after you've invoked, a skilled interrogator is going to be able to overcome pretty quickly what your attorney told you beforehand. And so you can't lie and shouldn't be allowed to lie and say, hey, your attorney, I think you told him, I'm your advisor, your attorney trusts me, your attorney didn't bother to show up today because he trusts me so much.
That's on the record? That's in the
Yes.
transcript? What you just said?
Yeah, I think it's pages 2 through 13 of the transcript. The very beginning are where he's mainly laying it on thick about counsel. And I think at one point,
Said your attorney didn't show up?
he said it's not uncommon, and
I think he said
might grab it here.
sometimes the attorneys forget about scheduling and all that.
which to me makes it say, you know, your attorney's not here, no big deal, that, you know, they don't
I'm
really.
sorry, I thought the argument was that they were making it seem like his attorney was there.
There's some discrepancy in the record, Your Honor. So Kevin, at the original suppression hearing, testifies that I got the impression that my attorney was there outside the room and that everything.
He testifies in the transcript, he says something along the lines of, he told me my attorney was in the other room. And then
Which is also inaccurate. It's not,
They couldn't
Dwyer
find
didn't
it.
quite say that in the transcript, but that's how Kevin took it, that my attorney is outside.
So now I'm confused. So defendant thinks he's outside, but you were saying that the transcript shows that Dwyer was saying he's not even here.
My reading of the transcript is that Dwyer is saying, indicating that counsel isn't there. The attorneys sometimes don't even bother showing up or forgetting about this because, you know, I'm trusted by the state of Michigan, the county of Genesee, and your attorney is, I think, what he says later. Kevin, at the suppression hearing, testifies that he took all of that to mean that counsel was there, like just waiting outside. I don't know how he got that impression, but that was his testimony. It is
So
a little.
it's fair to say that there's just assumptions being made here,
There's-
based on us all reading the transcript after the fact.
There's a lot of crosstalk and assumptions being made by everyone, which is why I think Streeter is probably the most analogous to this case, where there's just not a meeting of the minds, both between the assistant prosecutor and the defense attorney and the client and the interrogator, and there's no way for him to make a valid waiver when nobody knows what's going on, except for the fact that Mr. Scott believes that he was trying to protect his client and that he had a valid lender agreement.
So I'm struggling with the no questions after the poly. Mr. Scott didn't seem, from the transcript, it didn't seem like he was really pushing on that. It was really I was told that it was going to be at 7 and that someone was going to let me into the building. He had witnesses. He tried calling one of the assistant prosecutors to indicate, weren't you supposed to let me into the building? But on the agreement, I didn't see really anything showing that there was something there, other than the prosecutor saying, I would have never agreed to that.
So the original motion to suppress, there is less about that second part of the agreement. He's focused on, hey, they rescheduled this, and they never really get to that second part. Because Judge Fullerton says, well, are you going to testify? It's at the Ginther hearing where it's more clearly set out on the record through Mr. Scott's testimony in a number of places where he says, hey, there was a second part of the agreement for no post-polygraph questioning.
Right, so in the Ginther transcript, that's what he says, and the prosecutor says, I would have never agreed to that. That's not how we
He
do it.
says, I have no memory of any of this stuff, but I would never have, I can't imagine I would have agreed to that. The only reason I do these things is to get people to make admissions.
Can we proceed with this, and can you be successful if we're only talking about the 7 o'clock scheduled polygraph with Attorney Scott being present and that being moved earlier in the day?
I think so, Your Honor, because he testifies at the Ginther hearing, if I was in the building, I never would have let this go on for the length of time that it did, and I would have stopped it. Because he would have known, based on his prior experience, now this is me saying this, not him, but he would have known based on his prior experience with that FBI agent that he almost got into a fight with, that they're going to try to violate the agreement.
And he did tell defendant, do not answer any questions after the polygraph.
That is what he testified to, but he didn't.
And defendant testified that his attorney told him, do not answer any questions after the polygraph.
I don't know that Kevin testified to that, or if anybody actually asked him that at the motion.
I think it's in the
suppression
transcript.
hearing.
I'm
It
not
could
sure.
be.
I'm not sure what page, but yeah, I recall reading in the transcript.
Did Kevin not perform well during this examination? Is it an attorney's nightmare? Yes, but that's why you don't send this 18-year-old kid in there alone without this ironclad written agreement. Because you cannot count on them to defend themselves.
Do you want us to adopt a bright line that all agreements for a defendant to take a polygraph need to be in writing?
Do you have to say that that's what has to happen in order for the defendant to take one? No, but I think you can say that it is ineffective assistance not to memorialize it and not to otherwise mitigate this for your client and send them in alone to do this. There's a lot in the case law about, trying not to isolate the client from the defense attorney, and he let that happen, and he has to know how dangerous that is.
Okay, so I'm going to ask you again, because it sounds like you said no, but then when you answered, it sounded like you said yes. So I think you're asking us to say that a defense attorney has to have an agreement memorialized.
Well, I thought you were asking if
to-
there had to be a rule that you can't do these without such an agreement, which is sort of the distinction between Ray and Leonard. We don't think you need to make a blanket thing, as in interrogations from polygraphs are illegal, unconstitutional, they can't be done.
No, but if they're going to be done, it needs to be memorialized.
If you
In
want to
order
not
to
commit
avoid
malpractice, that would be a very good idea, but can they happen? Like, is it misconduct or somehow, it's on the
I'm asking
attorney.
what you're asking of us.
I am asking you to apply Leonard, Streeter, and Edwards, and under any three of those, this was an invalid waiver, largely due to ineffective assistance of counsel.
And is it always ineffective assistance of counsel if the agreement is not memorialized?
Can I say that, if one of you was charged with murder and I was representing you and you said you wanted to go take this polygraph, maybe I would consider it. If you said my 18-year-old child's been charged with murder and I want him to go take a polygraph, I would tell you absolutely not. And if you try to do that, you need to get a different attorney.
Good afternoon. Lauren Gottesman on behalf of the Innocence Project. The Innocence Project is here today to call attention to the grave risk of false confession at play when a teenager is left alone with an interrogating officer after a polygraph and encouraged to waive their fundamental right to counsel by executing an uncounseled Miranda waiver. The court's ruling in this case has the power to either mitigate or aggravate the risk to the innocent in the interrogation room. And before discussing the danger of officers presenting failed polygraph results as conclusive proof of guilt, I'll begin, if I may, by addressing the second question before this court today regarding Kevin's waiver of his rights. We're urging the court to hold that a person cannot, and at a minimum a teenager cannot, validly waive their fundamental right to counsel under the Michigan Constitution once that right has attached, as it had here, by merely waiving Miranda. Under the federal rule announced in Montejo, a Miranda waiver is generally sufficient to waive the federal Sixth Amendment right to counsel, even after it's attached. However, as other state Supreme Courts have recognized, the federal rule allows police to isolate a represented person from their lawyer, and like here, allows officers to attempt to convince the person that it's the officer and not their attorney that is there to help them, that is their advocate. And when officers are permitted to exploit counsel's absence in this way, innocent people are deprived of the very protection that this state's constitutional right to counsel is meant to provide. And this case exemplifies the danger with such a rule. Here, an 18-year-old was not with his lawyer when he was left to parse through the lies and false assurances by the interrogating officer, and then having waived Miranda, was subjected to dangerously coercive interrogation tactics that have the power to induce the innocent to confess. And I'll discuss those more in a moment, but this court has repeatedly said that the right to counsel must be protected with broad prophylactic measures. And perhaps most significantly, in 1984 in People v. Bladel, which is cited in our brief, the majority of this court agreed that once the right to counsel attaches, that right cannot be validly waived based solely on a Miranda waiver. And despite Bladel, some appellate courts have relied on Montejo to find that a Miranda waiver is enough to waive this fundamental right. So guidance from this court is therefore critical. So we're asking the court to clarify that the rights protected by Article 1, Section 20 of the state's constitution cannot be forfeited merely by an uncounseled Miranda waiver. And at minimum, or in the alternative, we're asking the court to hold that the state's right to counsel cannot be validly waived away by an adolescent who is unlikely to have a functional understanding of Miranda, who's categorically more vulnerable to police coercion, and who was at heightened risk of falsely confessing. And so unless there's questions on that issue, I'll move on to address the risk of false confession involved when, as here, a suspect is physically strapped into a device that they're told is a cold, impartial scientific machine, and that based on the results of that high-tech test, the police know conclusively that the suspect was involved in the crime. As explored in our brief, the polygraph is not a cold, impartial machine that simply spits out scientific results. Rather, it's an unreliable investigative tool that produces results that are subject to the examiner's implicit biases, and which are so unreliable, they're of course inadmissible in evidence in this state, as well as in nearly every other state in our nation. So stated simply, the polygraph cannot accurately or conclusively determine whether a suspect was involved in the crime, but officers routinely make this false claim to suspects in their custody. And this court very recently in Stewart expressed concern about the risk of false confession when officers lie about evidence in interrogation. And rightfully so. Police lies about evidence, known as the false evidence ploy, have been used to elicit the vast majority of proven false confessions. In fact, experts who have studied the power of this tactic overwhelmingly agree that it's equally dangerous as express promises of leniency, threats, and even torture. So the concern this court expressed in Stewart about the officers' lies there are equally, if not more, warranted here. In fact, when an innocent suspect is confronted with failed results of a polygraph that they've been led to believe are foolproof, they may even begin to question their own memory about what happened and doubt their own innocence. If you will indulge me for a moment, if you take, for example, the case of Peter Riley. Peter was 18 years old when he came home and found his mother had been stabbed to death. He calls for help, but then he's taken in as a suspect. He's given a polygraph. There's a transcript in this case, so we know that he was told it was an infallible machine and that he failed the test. Confused by the results, he starts telling the officers, "The test is giving me doubts," and he starts to question his own guilt. And ultimately, during that post-polygraph interrogation, he confabulates a false memory of guilt and confesses. It's entered into evidence. He's wrongfully convicted and exonerated a few years later when compelling evidence pointing to the true perpetrators was uncovered. I see my time's out. If I may just wrap up, my point here is that Peter's case is not an anomaly. This is not theoretical. In fact, 20% of individuals who falsely confessed were later exonerated by DNA evidence were administered a polygraph exam. So to help prevent future wrongful convictions, we're asking the court to consider the risk of false confession that results when a lawyer's actions or inactions leave their client, and especially a teenage client, without the guiding hand of counsel in a situation like this, a situation that is ripe for producing a coerced and potentially false confession. So if there's no further question, I would just like to thank the court for allowing us to participate today. Thank you.
And please, the court, Michael Tesner appearing on behalf of the appellee in this case. I want to correct a couple things first. The only reason the defendant was there for a polygraph examination is because he requested it. The defense and amicus assert that the prosecution here was being unfair and dishonest somehow. This is absolutely not true. We are ministers of justice, and Mr. Layton takes his role seriously and we act ethically and honestly. And if there were an agreement with counsel for no questioning, we wouldn't have admitted the statement. There was no dishonesty or manipulation on the part of the prosecutor or the polygrapher. The polygrapher moved up the time. He admitted that. He moved up the time for his own convenience that day, unaware that the defense attorney wanted to be there. And he made counsel available by phone, and the defendant even testified that he believed that counsel was in the next room. In fact, there was no agreement, and if there was any agreement, in fact, the defense just admitted there was no meeting of the minds. There was no agreement. The only possible agreement, though, as Chief Justice Clement asked about, is would counsel be allowed in the building? Now, the fact that counsel wasn't there didn't affect the voluntariness of the waiver because the defendant never asked for him, and even defense counsel testified he was not going to be in the room. He was only going to be available if he was asked for. The second thing is a polygraph is not some manipulative procedure that is only used against defendants. Polygraphs are a tool that benefit defendants many times. They have real value to a defendant. Defendants do, if they do pass, and then they use a polygraph for a real benefit, which is the opportunity to establish that they're being truthful. It can result in dismissal, reduction of charges, but also in a CST case, a defendant has a right to a polygraph. The legislature has given defendants that right, and they do that. They take polygraphs repeatedly, or often, I should say. And defendants can and do use them in support of a motion for new trial. This court has allowed that procedure, that a defendant can present a polygraph of someone who's recanted or a newly discovered witness and try to convince the trial judge that that witness bears belief. In fact, Sato has done this in one of my cases. And it's been, polygraphs are not excluded because they're unreliable. They're excluded, according to Barbara, People versus Barbara, because of the danger that they'll be overvalued by a jury, and especially because they are resolving an issue that's in the province of the jury, whether a witness is telling the truth, whether a witness is
Can we
credible.
go back to the set time for the polygraph at 7, and Mr. Scott thinking that he was going to be present for that? And I understand that you say it was a decision by the administrator of the polygraph to move it forward for his own convenience. But can you see that when a lawyer maybe asks to be present, understanding he can't be in the room but in the building, that it may be to confer with his client beforehand, to reaffirm immediately before the polygraph, I've talked with the prosecutor. You are going to do the polygraph, and then do not answer any additional questions. If you need me, I am right here. Can you see that exchange and the desire for the attorney to be present serves a purpose other than, oh, here's the phone, call him if you need to?
Well, it could mean that, but I don't think that's not the testimony in this case. Mr. Scott, first of all, he was retained by this defendant before he even turned himself in. He represented him for 3 months before, or 2.5 months before this polygraph took place, and he discussed the polygraph with the defendant and his parents, explained the procedure, and he told him not to make any statements after the test was over.
But he, as counsel has said, he's 18, right? And she used the example, one of us, I'll use me. If someone tells me to, do the polygraph, which I probably wouldn't do, but to not answer the questions afterwards, I'm not going to answer the questions afterwards because I'm informed. I don't need an attorney to tell me that. But an 18-year-old might have an attorney tell them this is the process, and they're thinking, I've got all this stuff going, and it's going to happen at 7, and I talked to my parents, and it's happening at 7, and then it gets moved up to, I wasn't entirely sure, 1:30. That's a significant time shift, and then the attorney's not present to have that conversation.
Well, I don't think that the evidence in this case showed that the attorney was going to talk to the defendant before the polygraph. He doesn't say that. In fact, what Mr. Scott testified to is that he wanted to be there in the building in case his client had a question. And the defendant never asked for his attorney. But
Can I add though the fact that, onto those facts that the chief was just talking about, where he says, I want to give the truthful person comfort that I will be their advocate. You know what an advocate is? I don't stand beside you and I don't stand behind you. I'll stand in front of you and I'll say you have to go through me to prosecute you. He's basically saying, you don't need your attorney because you got me, right?
Well,
isn't that relevant to?
Yes, I think, is it relevant? If that occurred before his waiver, then yes, I think it's relevant. But I don't think it's dispositive. And I don't think he was saying, you don't need your attorney. I don't think he said anywhere in here that you don't need your attorney, or your attorney said or decided not to show up. I don't think that's what Mr. Dwyer said from the transcript and from listening to the audio. But he did say.
He goes on to say he can't give comfort to a liar, and he gets on a big expose about that as well, right? So you can't just pull one part of it out of context.
Yes, I agree, Justice Viviano, and I was going to say next that he's saying that if you're truthful, the premise of this is the defendant wants to come in and explain that he wasn't involved in this criminal activity. And Dwyer is saying, if you're truthful, I'm going to stand in front of you and I'm going to tell the prosecutor and the judge, and I'll tell the defense attorney that you were truthful. And at the same time, they do discuss, if you're lying, then I'm going to be truthful about that too. I'm going to tell them that you're lying. So he's not saying I'm an advocate for you. He's saying I'm an advocate for the truth.
But counsel, it does kind of come off that way.
I'm their advocate.
Yeah. It does kind of come off that way, right? Like, and every day, a normal person would kind of see it that way, right? That he was like, you're going to have to get through me.
I think, yes, he did say that. If you're telling the truth, I'm going to stand up for you. I'm going to stand up for the truth. This is at the point where the defendant is coming in to say, I didn't do anything. Well, I don't think that's actually inaccurate. He would do that. He would, and if he, but he, in his, first of all, there's two different things here. One is the waiver, which he painstakingly, I think is the word that was used, painstakingly described his rights and even corrected him at one point. He knew he had the right to an attorney. He knew he had a right to have him there whenever he wanted. All he had to do was say so, and he had the right to stop questioning if he wanted. And then he laid down, this is what we're here for, and this is, if you tell the truth, I'm going to be there for you. I'm going to tell them that you told the truth. But if you lied, I'm going to tell them that you lied.
But what about the whole soliloquy about the phone? Like he was going to let him use his phone to call, his girlfriend, and, kind of very, kind of building up that level of trust. Like, hey, it seemed like it was more than just if you're telling the truth. It seemed like I'm like your genuine advocate, because if you could go into that whole issue where like he was talking about, like, well, when we're done, you can, whoever you want to call, please feel free to use my telephone. I mean, it would seem to a person, especially a younger person, that this is like a person that actually believes in you and is going to be advocating.
Well, he offered to let him use his phone to call his attorney. And yes, of course, he wants the defendant to talk freely with him. That's the purpose of being there, is for the defendant to talk freely and tell what the truth is. And he's going to report it back to everyone.
Yes, so like, it's a slightly different hypothetical, and would it change, or slightly different facts? Let's say instead, let's take the polygraph out of it. Let's say that through counsel, the defendant says, we're going to talk, we want to sit down and talk with the prosecutor, and we're going to do it. I'm going to be there with you. We're going to talk at 7 o'clock. So he knows that there's, we've agreed, my counsel's advised, like, this is a good thing to do. And then they come at 1:30 and say, you can call your counsel if you want. Like, so he presumes he's going to talk to him. Is that a valid, and he talks to them, is that a valid waiver?
If the defense attorney is part of the agreement that he's going to talk to the defendant?
Let's say from the defendant's perspective, he knows that he's going to have a conversation with the prosecution. His attorney says, yeah, we're going to be there. I'll be there with you. We're going to have this conversation. And the prosecution comes and has this conversation earlier, but without his attorney present.
Well, I think it's incumbent on the defendant.
And the defendant proceeds to go ahead and talk to him.
To the prosecutor or
Yeah.
to the officer.
Yeah.
I do think it's incumbent on the defendant to then say, I want to talk to my attorney. He's told he can. If that was his expectation, he was given, Dwyer went over it in detail. Can you have him right now? Yes. Can you use my phone to call him right now? No. Yes, you can. You can use my phone and call him right now. He was told that.
Is there a distinction from the example Justice Kavanaugh just gave you and what happened here? Because here there was a waiver.
Yes.
The waiver has to take place. It can't, the law enforcement, or the prosecutor couldn't sit down and with the defendant thinking that their attorney is going to be present, and if their attorney isn't there, the prosecutor can't just continue having conversations with them. There has to be a waiver.
Oh, yes, and I'm sorry if I missed that. Yes, if there was no waiver of Miranda, then I agree with you. There has to be a Miranda waiver before the prosecutor or the state can talk to the defendant in this situation without his attorney present, because he does have an attorney. But this isn't, I want to correct something else. This is not an uncounseled waiver. The defense attorney talked to his client and told him what was going to happen. And it's not uncounseled. He had counsel. That was the whole purpose of going to the polygraph, was to talk. And again, I don't think there's anything in the record, even from Mr. Scott's testimony, that he believed he was going to sit down and talk to him before this polygraph. He had already done that. With regard to People versus Stewart, okay, so number one, actually, let me talk about the amicus argument. This is the issue in this case is whether there was a knowing voluntary waiver of right to counsel. Amicus is arguing that the confession was involuntary. This is not a false confession case. There has never been the issue in this case. It was never raised. The defendant has not ever claimed that he only confessed because he was told he failed. So if you go through the different characteristics that were discussed in factors discussed in Stewart, they do not show that this was an involuntary waiver. I mean, if you want to just as in Stewart, there should not be a categorical exclusion or a categorical rule that young adults cannot waive Miranda without counsel present. Not only is that uncalled for, it would harm defendants, as there would be fewer or no polygraphs if that were a requirement, if there were a categorical ban on 18-year-olds. Even if the court adds importance to the age factor, it should still remain a case-specific, fact-specific inquiry under the totality of the circumstances. Particularly in this case, the court should not impose a categorical waiver or a rule. The issue was not raised, and so it was not fully briefed, and it would be bad policy to allow this argument to be added to the case this late in the process, contrary to preservation requirements and without any real opportunity for a response. And in fact, I talked to Mr. Dwyer about this case. There are cases around the state where defendants are challenging polygraphs, where the Innocence Project is challenging polygraphs based on the same arguments they're making here. Those are the cases that, if it ever percolates this high, should be an argument in those cases, not in one where it wasn't even raised as an issue until a month ago. And unless there's any other questions?
Don't see any.
Thank you.
Thank you. Thank you all. The case will be submitted. We will take a recess until 1:20.